Hi, my name is Shea Krauskopf. I'm an attorney with the law firm Wadler, Perches, Hundl, and Kerlick, and I'm here today to make this quick video to discuss material liens and mechanics liens. They're oftentimes referred to as M&M liens, and that's mostly what I'll refer to them throughout this video. So before we get too far into the key considerations that you should consider when preparing to record one of these liens, it's important to note that you're not recording a lien on the individual themselves or the general contractor as the individual. Instead, you're recording the lien on the property of the owner. So it's important to keep that in mind before recording these liens, and it's oftentimes that's oftentimes a misconception with general contractors and subcontractors. So as I said, we're going to discuss several key considerations. The first thing to consider is what type of project you're working on. There are big differences in the rules that govern residential properties versus commercial properties. So it's very important to know before the outset of the project which type of project it is. But for today's video, we're going to stick to commercial properties, and we're going to discuss the further considerations involved in recording a M&M lien on a commercial property. So the first big thing to consider after you've determined what type of property it is to consider what level of contractor you are. Now that's going to have a big impact on your filing dates and your notice provision dates. So it's important before you even start the project that you understand what level of contractor you are. In Texas, there's generally 3 levels: the original contractor, a subcontractor, and a sub-subcontractor. The original contractor is going to have a contract directly with the owner of the property, as in they're going to be the person communicating with the owner of the property and then hiring subcontractors and etc. underneath them. A subcontractor is going to have a contract directly with the original contractor and not the owner of the property. And thereafter, a sub-subcontractor is going to have a contract with a subcontractor and not the owner of the property or the original contractor. So it's very important to determine before you start the project what level of contractor you are, because this next part is going to be greatly dependent on what level of contractor you are. So the original contractor certainly has it the easiest when recording a M&M lien. Unlike a subcontractor or a sub-subcontractor, the original contractor simply has to record the lien affidavit and is not required to send any additional notice provisions except after the lien is recorded. So the original contractor simply has to record the lien affidavit by the 15th day of the 4th month after the project or after the debt accrues. Generally speaking, the debt will begin to accrue when the project is either completed or the contract is terminated. So by way of example, if you're the general contractor on a project and you haven't been paid for the month of March, you'll have to record your lien affidavit with the county clerk of the county in which the project is located by July 15th. So it's also super important to keep in mind that there is a notice provision after you've recorded the lien affidavit, and that is you have to provide the owner of the property notice that you've recorded the lien within 5 days of recording the lien. So it's super important that that's taken care of as well. So moving forward, if you're the subcontractor on a project, you will have an additional notice provision that the original contractor is not burdened by. If you have a contract with the original contractor, not the owner, you first have to give the owner and the original contractor written notice of an unpaid claim by the 15th day of the 3rd calendar month following each month in which you performed labor or delivered materials in which you haven't been paid for. As a practice tip, it's also important to send these notices via certified mail return receipt requested. That way you can prove that the original contractor owner actually received the notices. So, for example, if you performed work or delivered materials in March and you have not been paid for that month, you must send notice to the owner and general contractor by June 15th. Also, keep in mind that if you've not been paid for multiple months, you will also have to send these notices for each month thereafter that you haven't been paid for. So, for example, if you were not paid for the month of April as well, you'll have to send another notice to the owner and original contractor by July 15th. Next, if you still aren't paid after you've sent your notices, you'll then have to record your lien affidavit by the 15th day of the 4th month after the last month in which labor was performed or materials were last furnished. So again, by way of example, after you've sent your notices that the last month you performed work in was April, you'll have to record your lien affidavit by August 15th. Also, keep in mind that you again have to comply with the 5-day rule, as in you have to provide the owner notice that you've recorded a lien within 5 days after recording that lien at the county clerk's office within the county in which the project was completed. So finally, moving on to the subcontractor, and this is where it gets a little bit more complicated. And forewarning, as a subcontractor, you've really got to be on top of this because your notice provisions are very tight. So if you have a contract with a subcontractor, not the owner or original contractor, as mentioned, your deadlines are even tighter. So to start, you'll have to give written notice to the original contractor not later than the 15th day of the second month following each month in which you performed labor or provided materials. So, by way of example, if you've not been paid for the month of March, you must send notice to the general contractor by May 15th. As a practice tip, again, you should always make sure to send these notices certified mail return receipt requested as well. Also, another practice tip, even though you're only required to send this first notice to the general contractor, you might as well go ahead and send this notice to the subcontractor that you were hired underneath as well. Next, if you still haven't been paid, you have to send a second notice to the general contractor and the owner of the project by the 15th day of the third calendar month for which work was performed and you were not paid. Again, by way of example, if you haven't been paid for March, you'll have to send your first notice to the original contractor by May 15th and your second notice to the general contractor and owner by June 15th. So finally, if you still haven't been paid after you've sent both of your notices as the subcontractor, you can go ahead and record your lien, but it has to be recorded, your lien affidavit has to be recorded by July 15th. So as you can see, M&M liens can be complicated, and there are very strict notice deadlines that you have to comply with. These statutes are interpreted very strictly by the courts, and if you miss a deadline, unfortunately, your lien is probably not going to be valid. So therefore, it's super important to contact an attorney that has experience in recording these liens to assist you through this process. So again, my name is Shea Krauskopf. I'm with the law firm Wadler, Perches, Hundl, and Kerlick, and I thank you for watching.